So you bought a protein bar because the label said 150 calories and 28 grams of protein. You were trying to be responsible, trying to be healthy, and according to a new class action lawsuit, you may have actually eaten 275 calories and 13 grams of fat. Your situationship lied to you less than that label did. We need to talk. Welcome back to Exhibit A List, where pop culture gets cross examined and nobody leaves without a legal education. I'm your host, Jasmine Wegg. I'm a lawyer, and this week we have a lot going on. Travis Kelce and Patrick Mahomes got sued over their steakhouse name, and I promise you the timeline on this trademark fight is messier than their offensive line. Meta's CEO Mark Zuckerberg is on trial in New Mexico, and his testimony is really something. A below deck deckhand is suing Bravo for $850 million over allegedly being manipulated into a fake romance and then blacklisted from yachting. The David protein bar brand that you're seeing everywhere, everyone's favorite gym girly snack, is now facing a class action lawsuit claiming those 150 calorie bars are actually closer to 275. And in petty court, we're settling the birthday trip debate once and for all. Okay, let's get into it. If you're not following me, fix that immediately. My Instagram is JasmineWagESQ. The podcast is at Exhibit A List Pod. TikTok is Jazz the Lawyer. DM me after this episode. Tell me which story got you. If you're listening, screenshot it and post it to stories and I'll repost. If someone in your life needs to hear this, please send it to them. You'll be doing them a favor. Our first story is Kelce and Mahomes getting sued over a number. Okay, we need to start here because this one is actually kind of wild and I was not expecting to feel complicated feelings about it, but here we are. Travis Kelce and Patrick Mahomes opened a steakhouse called 1587 Prime. If you don't know the reference, Patrick Mahomes wears number 15 and Travis Kelce wears number 87. Combine them, you got 1587. They put it in a hotel in Kansas City, and it's actually been doing great. Honestly, kind of cute branding. And then a sneaker company called 1587 Sneakers sued them for trademark infringement. So here's the situation. 1587 Sneakers is a small shoe brand. They appeared on Shark Tank in 2024. They claim they started selling shoes under the 1587 name back in April 2023, which is before the restaurant opened. So they're arguing, we were here first, you took our name, and now customers are confused. But here's where it gets complicated. 1587 didn't actually apply to trademark the name until October 2025, which was 1 month after the restaurant opened. And Patrick and Travis had already applied for their trademark way back in December 2023. So who wins this? So let's break down trademark law, how it actually works, because most people think that you just file a trademark and you own something. And it's of course not that simple because nothing in our legal system ever is. In the United States, we have what's called a first to use system, not first to file. That means the person who actually used the name in commerce first has a stronger claim. You don't automatically get rights just by filing paperwork. You get rights by using the mark in the real world. So 1587 sneaker argument is we were selling shoes with this name before you ever opened a restaurant. We were first. We have common law trademark rights even without a registered trademark. And that is a real legal argument. Common law trademark rights are a thing. You don't need to register with the U.S. Patent Trademark Office to have some level of trademark protection. Using a name in commerce gives you rights in the geographic area where you're actually operating. But here's the problem for 1587 sneakers. Trademark infringement requires a likelihood of consumer confusion. And the question is, would a consumer actually confuse a sneaker brand with a Kansas City steakhouse? The sneaker company is saying yes, because the restaurant sells merchandise with the 1587 name on it, which overlaps with apparel. And so they're saying that customers have already reached out to them thinking that there's a connection. And my thought is like, wouldn't that connection only help you, like being tied to Patrick and Travis? Now, Patrick and Travis's defense is going to be that we applied for a trademark over a year before you did. We're a restaurant, you sell sneakers. These are entirely different markets. The fact that you share four numbers doesn't mean there's confusion. And honestly, there's a very good point there. Trademark law only cares about one thing: confusion. Are consumers actually confused? If I'm buying a steak dinner in Kansas City, I'm not thinking about a sneaker brand from Shark Tank. And if I'm buying sneakers, I'm not thinking about Patrick Mahomes' restaurant. So the confusion element just doesn't seem to be there. The wrinkle, though, is that merchandise. The restaurant does sell merch with 1587, and the clothing that is in the same category as sneakers. That's where 1587 sneakers actually has a stronger argument. Not about the restaurant itself, but about the branded apparel the restaurant sells. There's also an issue of timing that's worth noting. The sneaker company claims that they've been using the 1587 name since April 2023. If that's true, they were technically using it in commerce before Kelsey and Mahomes applied for their trademark, but they didn't bother to register it until a month after the restaurant opened. That is going to hurt them. Because here's the thing: registering your trademark is not just bureaucratic busywork, it creates a public record. It puts the whole world on notice that you're claiming the name. If you wait to register until after someone else has already become nationally famous with a similar name, it starts to look a little bit opportunistic. I'm not saying that's what's happening here, but I do think that's how many people are perceiving it. If I were advising either side as a lawyer, this is the kind of case that you want to settle quietly. Litigation here is expensive, discovery is messy, and I don't think either side is really going to benefit from dragging this out. 1587 Sneakers is a small company. They were on Shark Tank, but they don't have the resources to litigate against two NFL superstars and their hospitality group. And Patrick and Travis probably don't want the press nightmare of being seen beating up on a small business. So, settlement here seems to be the best outcome for both sides. The lesson here for all of us who have businesses or side hustles or brands is protect your name early. Register your trademark before you get famous, not after. Because once someone with more money and more fame uses a similar name, going to be the one who looks like the problem even if you got there first. And now we got our boy Mark Zuckerberg in trouble again. This point, it's basically a recurring segment on this show, and I'm not mad about it, but Mark Zuckerberg has gotten himself into a bit of legal trouble. Here's what's happening. Meta is on trial in New Mexico. The state's attorney general is suing Meta, alleging that Facebook and Instagram are designed in ways that put profits over child safety, and specifically that Meta's platforms have enabled predators to exploit children. So, this is another different avenue of lawsuits against Meta. I've been talking about the social media addiction lawsuits that have been playing out, and this is another avenue where they're being sued. During this trial, they played tape depositions of Zuckerberg and Instagram's head, Adam Mosseri. And what Zuckerberg said on tape is, I want you really to hear this. He said, and I'm paraphrasing, not quoting directly, that when you're serving billions of people, some small percentage of them are going to be criminals, and the company can never be perfect. Harm is essentially inevitable at that scale. Now, I understand, of course, what he was trying to say, and that's that no system can be perfect, and Meta isn't responsible for every bad actor who uses its platforms. That is a reasonable argument in the abstract. However, here's the problem with saying that on tape in front of a jury. You just told the entire courtroom that you knew harm was going to happen. You knew children were going to be exploited, and you decided to keep running the platform the way it was because he's saying that a certain level of criminal users is to be expected. Zuckerberg basically said when billions of people use a platform, some harm is inevitable. The legal problem is if harm is inevitable, then harm is foreseeable. And foreseeable harm that you don't prevent, that, my friends, in the legal world is called negligence. So when he says that on tape in front of a jury, that is akin to a confession. So let's talk about what else came out of this trial because it does get worse. The court heard evidence that in 2020, Meta estimated that around 500,000 children were receiving inappropriate communications, sexually inappropriate, on Instagram every single day. And the company knew this. There was also testimony that Meta's People You May Know algorithm, the one that recommends accounts to connect with, was identified as key drivers of predators finding child victims. In 79% of identified cases in 2018, that algorithm was used to locate victims. And even after Meta's own child safety groups warned that end-to-end encryption would make it harder to detect child sex abuse materials, Zuckerberg authorized it anyway because he said privacy was a more pressing issue. So to be fair here, Meta has made changes. They launched the teen accounts in 2024 with strict default settings. They said that they've invested billions in safety technology, and no platform is going to be perfect when you have 3 billion monthly users. But the argument that harm is inevitable doesn't get you off the hook legally. It actually makes it worse because inevitable means foreseeable, and foreseeable harm that you don't take adequate steps to prevent, as I said, sounds like negligence. The legal theory in this case is similar to the product liabilities cases that we've talked about in episode 21. The state of New Mexico is essentially arguing that Meta's platforms are defective products, not because they don't work, but because they were designed in a way that prioritizes engagement and profit over user safety. And the internal documents are devastating. When your own company's research is saying 500,000 kids are being targeted every day, and your response is basically like, that's the cost of scale, that is very hard to defend. Here's my legal take. This is going to be the lawsuit that could take Meta down. The company has unlimited legal resources and very smart lawyers, but every one of these trials chips away at the legal and public argument that Meta is just a neutral platform that can't be responsible for what happens on it. The word just a platform defense is dying. Courts are increasingly willing to look at how these products were designed, what decisions were made, and whether those decisions put profits over people. And right now, the evidence suggests they did. I'll be watching this trial closely, and if there are updates, your girl's gonna bring them to you. Now, moving to Bravo, because there's always drama where Bravo is concerned. This one is for anyone who has ever watched a reality TV show and thought, wait, did they actually just do that to a person? A former Below Deck cast member named Emil Coates has filed an $850 million lawsuit against Bravo and NBC Universal. The allegations in this complaint are something. Here's the background. Emil was a deckhand on season 3 of Below Deck, way back in 2015. He was 23 years old. He was a professional yachtsman from South Africa, and he said that he was told that the show was a documentary style series about yacht life that would benefit his career. He found out it was a reality show once he got there and the camera started rolling. According to the lawsuit, producers pushed him into fake romantic storyline with a coworker named Raquel who went by Rocky. They allegedly encouraged excessive drinking, told him what to say to her, and then they edited the footage to make him look obsessive and sexually aggressive. He's accusing producers of something called frankenbiting. Now, frankenbiting is super interesting. It's when editors splice together clips from different conversations to make it look like you said something that you did not. For example, he says he jokingly said that he might marry Rocky in one conversation. Producers allegedly cut that clip and put it next to a scene of her rejecting him. So that makes him look like a delusional guy who couldn't take a hint. He says that the portrayal blacklisted him from the yachting industry. He couldn't get work. Now he's claiming $123 million in lost future earnings as a yacht captain, plus emotional distress, plus $500 million in punitive damages. He also says that there were genuinely dangerous situations on set. A crew member was jumping overboard, a fire in the kitchen, producers did not take things seriously, they just kept filming. And he's alleging that he was paid less than the American crew members because he was South African, which is a discrimination claim on top of everything else he's alleged. Now, let's have a little legal reality check here. The case has some real problems. The first one is the timing. Think about this. The show aired in 2015. He filed this lawsuit in June 2025. Anyone with a good legal head is going to go boom, 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 statute of limitations. This is 10 years later. NBC Universal is already arguing the statute of limitations. They want to get this dismissed. They're saying that the time to sue has passed. So Emil's response is that he was too traumatized to act sooner. He didn't fully understand the extent of what had been done to him until he read a Business Insider investigation about reality TV abuse years later. Maybe he listened to one of my podcast episodes and that galvanized him. I'm just kidding. There are legal doctrines that can pause the clock in cases of trauma or delayed discovery of harm, But that argument is going to, of course, be an uphill battle because there's a 10-year delay here. The second problem we have is the contract. Reality TV contracts are notoriously broad. We've broken them down on here before. They protect the drafter, and the drafter is the company. They typically include provisions giving producers the right to edit participants however they want, including in ways that are fictional. People sign these contracts, and I can tell you firsthand as an attorney, so many people sign contracts that they've never read. They don't read a word of them. They'll just scroll right on down to the bottom. If there was a quick button they could press to get the whole contract scrolled down, they would do that too, especially when it's a deal they want to close. But legally, Emil probably agreed to this, and NBC Universal is going to lean on that hard. And then there's a First Amendment defense, too. The network is arguing that editing and presenting a creative work is protected by free speech, and the courts can't tell them how to do it. Courts have given media companies significant latitude on this. But here's what's interesting. Emil is trying to use something called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which is a 2021 federal law that lets people bring sexual harassment claims to court even if they sign an arbitration agreement. That is a real avenue. And in another below deck case that I talked about on a couple episodes back, the plaintiffs were successful in getting this court into regular court instead of arbitration based on that act. But because of most of these reality TV contracts force disputes into private arbitration, which means there will never be a public record, there's no jury, no accountability, this act potentially lets him bypass that. However, what's also interesting about this case is that the judge in this case has already denied several of Emil's motions. And he was originally filing pro se, which means without a lawyer, and he has since amended his complaint with proper legal representation. The case is still active. He obviously is going against bigwigs with robust legal teams. So it's always a challenge. But when you have salient claims, you have salient claims. NBC Universal filed a motion to dismiss in November 2025 that has not been ruled on yet. My honest take is that the statute of limitations issue is going to be the biggest obstacle here. If the court decides that he waited too long, everything else will become moot. But if he can get past that huge hurdle, and if there are internal documents that show that producers deliberately manipulated him, this case can get very interesting and one to watch. And regardless of how this specific lawsuit goes, this is part of a larger conversation about reality TV labor practices. A lot of reality TV past and present celebs have been very vocal about this, speaking out. People are being recruited, manipulated, edited into villains, and sent back into real life with no support system and a destroyed reputation. That is a real problem, and I don't think that the industry can just keep on operating this way without consequences, as long as reality TV is going to be this huge industry that it is. Now let's talk about David Protein Bars, the lawsuit you didn't expect. I need to talk to my gym girlies and my gym bros for a second. Because if you've been eating David Protein Bars thinking that you are being responsible and disciplined, I got some news for you. A class action lawsuit was filed in January 2026 alleging that David Protein Bars contain significantly more calories and fat than what's listed on the label. Here's what they're claiming. The bars are marketed as having 150 calories and 2 grams of fat per serving. Independent lab testing done by the plaintiffs allegedly found that the actual numbers are somewhere between 268 and 275 calories and between 11 and 13.5 grams of fat. Let me do the math for you guys. That's up to 83% more calories than advertised and up to 400% more fat. 400% more fat. The gym girlies are crying. Do you guys remember that Seinfeld episode where everyone was going ham sandwich for this new frozen yogurt that was fat-free and low-cal? And then they didn't know why they were suddenly putting on weight. And it was because obviously it was not fat-free. And I remember Jerry's punchline was the fat is free. Everything else costs. But let me tell you a little bit about David Protein before we get into the legal stuff, because this is a brand that has been absolutely everywhere, doing the most. Launched in September 2024, and it got into over 3,000 stores almost immediately. It's one of 2 brands of protein bars that I see at my little boutique gym. Shout out Kings and Queens. They raised $85 million in funding and were projecting $100 million in revenue before its first birthday. They were endorsed by Andrew Huberman, now completely disgraced Peter Attia. I don't know, was that a hint? Should we have known with the Attia relation? Arnold Schwarzenegger, the World Health Influencer Industrial Complex was behind this bar. The pitch was basically 28 grams of protein, zero sugar, 150 calories. Sounds perfect, doesn't it? We've solved protein bars. This is the product that fixes the broken food system. And now there's a class action saying that the calories are almost double what they told you. So, what's the legal theory here? This is a consumer fraud and false advertising case. The argument is simple. You represented that your product is something that it isn't. Consumers relied on that representation. They paid a premium price for a product that they believed was healthier than competitors. You basically gave them a Cliff Bar. I don't know how David bars taste, but I hope they taste just as good as a Cliff Bar for 275 calories. Because I used to love those until I realized they were just a little bit too high to be the snacky snack that I was eating them as. Anyway, consumers were deceived. The FDA has regulations on nutrition labeling. The rules say that the actual nutrient content of a food cannot exceed what's declared on the label by more than 20%, which for some of us, that percent is offensive. Like we're counting calories, some of us, and even 20% discrepancy is a lot. But if these lab results are accurate, David protein isn't off by 20%. They're off by 83%, and that is not a rounding error. That's a completely different product than what they sold you. Now, David Protein has not publicly responded to the specific lawsuit in detail, but I want to give you some context about how the bar is made because there's a reason the calorie situation might be complicated. David uses a modified fat substitute called EPG, which is a plant-based oil that's been modified to be mostly non-digestible, meaning your body doesn't absorb most of its calories. Sounds like a frankenfood. The company's argument is that the Atwater method, which is the standard way calories are calculated for food labels, does not apply for EPG the same way that it applies for regular fat, because most of the EPG passes through your system without being absorbed. So there could be a genuine scientific dispute here about how to calculate calories in a bar that uses a non-standard fat substitute. The question is going to be, what method does the FDA require? And did David use a scientifically valid method, or did they just pick the number that looked the best on the label? Because 150 is a nice little round number. If the lab results hold up, this case is not going away. And it matters beyond just David Protein because this is part of a larger pattern of wellness brands making claims that sound credible and incredible because they're just like not possible. If you've been eating these bars, you do not need to panic, but like low key, let me know if you gained any weight. Just kidding. The calories you may have consumed don't disappear, but your purchase decision was made on false information, and that's what this case is about. Always read the ingredients list. That's the best way to know what you're actually eating if you can understand it in the case of foods like EPG. And now a quick little lightning round. Things I need you to know about. Meta AI glasses also getting a class action. Meta just can't stay out of court, folks. A new class action was filed in federal court alleging that Meta's Ray-Ban AI glasses were marketed as privacy focused, but workers in Kenya reviewing footage captured by the glasses have been exposed to intimate and private images from users, including footage of intimate moments, bathroom visits. Meta says it takes steps to filter this data. Are we trusting Meta anymore at this point? Yikes. Workers say the filtering system just doesn't always work. If you own a pair of these glasses, just know your footage may have been seen by a human you've never met. Make of that what you will. I'm going to avoid them. And now it's time for petty court. The court is now in session. Welcome to petty court, where the stakes are low, the feelings are extremely high, and I am the only judge that matters. Today's case is one I have been waiting to adjudicate. I have opinions about this, strong ones. Here's the facts, folks. A friend is turning 30. They plan a group birthday trip. It's a long weekend in a nice place, let's say a beach house or a wine country rental or Vegas. Doesn't matter. The point is, it costs money. The birthday person presents the group with a budget. They want everyone to split the cost of the rental equally. They also want everyone to cover their activities, their meals, their spa day, and they have expectations about how fancy things should be. And here's the move. When people suggest cheaper options, they say, "It's my birthday. I just want this one thing." So here's my question before the court. Is this a celebration or a financial hostage situation? Let me give the birthday person's perspective first because I am a fair judge. You turn a milestone age only once. You want your people around you in a place that feels special. You're not asking them to fund your whole life, just one weekend. And if people love you, they should show up for you, right? Okay, I've heard you, and here's my ruling. Your birthday, I'm sorry, but it's not a federally funded holiday. The government does not issue a blank check on your birthday. Your friends are not your dependents. And "it's my birthday" is not a legal defense for turning a celebration into a group invoice. When you plan a birthday trip and expect people to split costs according to your taste level, not theirs, you have quietly transferred the financial burden of your celebration onto your friends. And you've added social pressure on top of it. Because now, if someone says that they can't afford it, they feel like the bad friend who ruined your birthday or like they're being cheap. You've made it so there's no graceful way to opt out. This is a financial hostage situation. I said what I said. Here is what I think is acceptable. You want to plan a group trip for your birthday? Incredible. Here's how you do it without committing what I call birthday tax fraud. Option one, you cover your own share. If you want the fancy room, you pay for the fancy room. Your friends split the cost of their accommodations at whatever level they choose. You are not entitled to have your room funded by the group just because it's your birthday. Or option two, you're transparent upfront. You say, "Here's what I love. Here's what it costs. I totally understand if it's too much. No judgment. I just wanted to share what I'm thinking." And then you actually mean it. That's the important part. No guilt trips. No, "it's fine" with the face that says it's not fine. Or option three, someone who loves you, and they must really love you, has the means, offers to cover your portion as a birthday gift. And that's awesome and sweet and super generous and their choice. But you don't solicit this. That's not something you can expect, but you can let that be offered. What I think is unacceptable is planning the trip completely to your taste level and price point, especially if you're a bougie babe, and then presenting your friends with a bill and calling it a celebration. So the verdict is birthday trips are a privilege, not a right. Your friends are guests at your celebration, not donors to your vacation fund. Or plan within the group's means, or be honest about the cost early enough for people to opt out with dignity and then be cool about that. The "it's my birthday" card may be played once a year. Use it on something small though. Do not use it to override someone's budget because that's not super nice. Court is adjourned. That's our episode, folks. Kelsey and Mahomes got sued over a number, and the sneaker company that filed might have waited too long to protect their brand. Zuckerberg testified that harm on his platform is inevitable, which is not the defense he thinks it is. A Below Deck alum filed an $850 million lawsuit against Bravo over being manipulated and then blacklisted from his career. David Protein is being accused of labeling their bars with calories that may be almost half of what you're actually eating. And the birthday trip financial hostage situation has been officially banned by this court. Come tell me which story got to you. The Instagram is JasmineWeggySQ. The podcast Instagram is Exhibit A List Pod. And TikTok is Jazz the Lawyer. If you haven't followed yet, what are you doing? Please do it now. If you can leave a rating or review, it genuinely helps more than you know. And if someone in your life needs to hear this, send it to them. Thank you for listening. Stay curious, friends, and I'll see you next time on Exhibit A List.